Hi, how are you?
Good, how are you?
Good.
Welcome to Insta Live. Christina's first live, so that'll be fun. Okay, so we'll just give a couple minutes. I don't know if you can see the people joining, but we've got a couple people following so far.
Okay, great.
So, yeah. All right. So we are going to talk about this book, Trials and Errors. It's a really fun book, right, Christina? I think she read like most of it in one weekend, right?
Oh, yeah. It became very interesting. I was able to go through very quickly. I learned a lot of different things from all different celebrities.
Yeah. So it's fun stuff. So we're gonna just pick a couple today, and then next week or so, or next month, I'm sorry, we'll do some more. Just because I think it's really exciting and interesting to hear about, the famous people that we all know and love, and what they did right, and or probably what they did wrong. Their estate plans. So, all right, I guess we'll get started. We're a couple minutes in. Um, so the first one we're going to talk about. Okay, so this book, by the way, is Trials and Errors. It's written by two attorneys, Andrew Mayoras and Danielle Mayoras. So these were estate planning or are estate planning attorneys, and they put together this great book. So Christina here is my colleague. She is an estate planning attorney as well here in New York. She's been doing it for how many years?
Over 7 years now.
Okay, and just estate planning, so very focused, very concentrated. So she is a gem of information, so I'm super happy to have you on with us.
Thank you so much.
All right, so we are going to start with Jimi Hendrix. Hey, they got a little drawing in here, a little caricature, I think. Anyways, so Jimi Hendrix, as we all know, was a great guitarist and probably one of the greatest. He died at the age of 27 in 1970, September 18th, 1970. So that's really young. Like most of us do not think we're going to die at age 27. I'm sure there's not a lot of 27-year-olds with estate plans. Do you know? Have you heard of that? Yeah. So, what's important to note is that he had a younger brother, 6 years younger, Leon Hendrix, and they both kind of actually grew up in foster homes, and they were in separate homes at most of their lives, but they were really close. So they, one would assume that because they were close, Jimmy would have wanted his brother to inherit his estate. But Jimmy died intestate. So break it down, Christina. What is intestate?
So, intestate means when a person passes away without a will. So, if you pass away without a will, the state that you reside in, your domicile state, has laws as to who inherits your property if you don't have a will. So, here in New York, if you pass away intestate without a will, if you're married, your spouse gets the first 50,000 and then half, and your children get the other half. In Jimi Hendrix's situation, he was not married and he had no children. So because he died intestate without a will, New York said that his estate went to his parents, his father. His father was the only parent in his life. And as it went on, because his parent, his father, inherited, when his father died, it went according to his father's will, which left it all to a half-sister, who Jimmy didn't even know. So with all his money and all his fame and glory, the simplest thing of creating a will so that he could leave his brother something, maybe he didn't want to leave it all to him, or maybe he did. His wishes are never known and were never carried out because he didn't have a simple will.
Yeah, it's sad. So, of course, what happens? Litigation, right? So Leon, the brother, winds up suing. He's like, I'm entitled to the estate. In fact, Al, the father, created several versions of a will. So he did wills, and they mentioned that Al only had a seventh grade education, but he created a will, and then he got more sophisticated, which is typical when you're doing estate planning. You start with something, and it builds over time. So he did several versions and rounds of trusts and wills, and most of them had, and in fact, did have Leon getting about a quarter of the estate. But then at the last minute, he created a trust and literally excluded Leon and all of Leon's children to add this other daughter, Janie. So, of course, Leon sues, which means that, and there was a trial which lasted for 7 weeks. So we can only imagine how much the attorneys got. And I'm sure Jimi Hendrix did not work all that hard for these random attorneys to get the money. In the end, the judge said that Janie, although she didn't manage the trust properly and she wasn't very credible, he did believe that Al, the father, knew what he was doing. So it didn't even matter that this woman is coming in and messing it all up. The testator, the dad, was credible enough for the judge, and that's how it went. Anything you'd want to add, Christina, to that?
I was going to say, when you have good attorneys who you go to do your estate planning, as I'm sure Al had, he started out with a very probably basic, simple will, and as the years went on, it became more intricate and more, advanced as the years went on. And because he had such great estate planning attorneys who did their jobs right and made sure that he had the capacity to sign these documents when he executed them, when he signed them, a judge upheld them and said he did have capacity. And so, unfortunate for Leon, although he was trying to say that Dad didn't know what he was doing, a judge held that he did, and his estate planning documents, carried out his wishes, even though maybe Jimmy's wasn't, and that's where he got a lot of his money from.
Yeah. So really interesting. Leon went far. He went all the appellate courts. He created his own company. She shot that down and took everything. So Leon basically got nothing. It's pretty sad. So, we really hope, Jimmy would have done a will. So lesson to be learned, even if you're 27, you should be doing a will, at least a will. So we're going to hop over to another great estate story, another musician. We're going to go to Ray Charles. This one is interesting too, of course. Okay, so Ray Charles had an estate valued at more than $75 million when he died of cancer in June 2004. Before he died, he had a meeting with his 12 children and their 9 different moms and told them that he was earmarking most of his money for charity, but was going to leave some money in trust, about $500,000 for each of them, and some cash gifts. And then he did multiple trusts. He created a charitable foundation and a company. So before I go on, why is he creating all these different things? I mean, maybe not everybody has that much money, but Christina, why do you think he's doing all these multiple trusts?
He probably wanted to do a trust maybe for each child. Each child, depending on their circumstances, may have needed an separate, what I call standalone trust. So sometimes we have clients who come in who their grandchildren maybe has a disability, or their child has a disability. So they want to make sure that they're protected in a different way than a grandchild or a child who does not have a disability. So sometimes different trusts needs to be created, as well as an estate with that large. His attorneys probably wanted to make sure he was trying to avoid the estate tax as best as he could at the time. So creating charitable trust is one way to, shelter some money and get it out of your estate. There's other trusts that are available to do that as well. So I'm sure that had a lot to do with why there was multiple.
So it sounds like some really sophisticated planning.
Also, is sometimes, and I don't know that it said it here. I don't know if Charles had multiple children with different women, but sometimes you have child A and B with your first wife and child C and D with your second wife. Well, if you lump it into one trust, well, who becomes the trustee when you pass away? Is wife 1 going to be the trustee for all of the children? Wife 2 certainly is not going to like that, and
Right.
vice versa. So I've had trusts where you make a trust for children A and B and let mom, manage that one, and then a trust for C and D and let the mom manage that one. So that's another reason why it could have happened.
Gotcha. Okay. And guys, if you're watching, please feel free to ask any questions. We're happy to answer them. All right. So then what did Charles do? He picked one guy, his homie, his longtime friend and advisor, Joe Adams, to manage it all. So we've got one, despite all the sophisticated planning, we only have one manager. So I'm sure we can guess what happened. There was a lawsuits filed against Adams in the name of Charles's offsprings. They alleged he mismanaged Charles's legacy, failed to disclose information, stole millions from the charitable foundation, and they launched an investigation. So worst of all, there was some concerns about what was happening with his father's image. This is a whole nother kind of legal avenue that we're not going to get into today. But there, publicity rights and who has the right to use the image on T-shirts and cups and all that kind of stuff. So that was not really addressed. So
I'm going to jump in for a second. So Ray
yeah.
Charles, with all of the trust that he created in this extensive estate planning that he had done, he thought he covered it all. But by forgetting to include what happens to his publicity rights, that became something for his heirs to kind of attach and go after and try to get to. So that's really important. I always have clients who say, well, I want my mother's engagement ring to go to my daughter, Susan. And then I say to him, well, we didn't put that in your trust, or we didn't put that in your will. Oh, well, I'll just write her a note. No. And here in New York, if it's not specified in the legal documents that we're preparing, then it's not going to be upheld in court. So that ring that you want to leave to your daughter, Susan, we have to make a specific provision for it. Otherwise, it's, has to be distributed according to whoever your beneficiaries are. So this is where he failed. This is one of the things he forgot. So it's always important to remember that any kind of property, any kind of rights, anything that you own, that you're specific about it. And is specific as to who do you want to get it, how do you want it to be distributed.
Yeah. Now we've got one viewer saying, this is Girl Got Grilled. She's saying, is there such a thing as co-executors? And I guess that's coming up because, what if Adams had a co? Would that have helped?
So yes, there's such thing as co-executors. So executors are the people who will take over your will once you pass away. So they're the ones who bring your will to court in what we call the probate process. So yes, you can have two co-executors. You can have 3. You can have 4. I always recommend not having any more than 2 because then it could create a problem amongst them. When you have too many, who's the head honcho and who's not. You can also have co-trustees. Trustees are the people who, oh my gosh, the word just slipped out of my head. They administer the trust when time comes. So you can have, as many as you want trustees, but again, I'd only recommend 2.
Okay, great. All right. So Ray's son, Ray Charles Robinson Jr., brought these lawsuits. Adam denied all the claims. And eventually, for what we don't know the details of, is that the cases were dismissed for lack of prosecution, which is a fancy word for they didn't do something right in order to make the case go forward. And so all the cases were closed. And, one thing that comes up later in this story, which is really important to mention, is we all know Ray Charles was blind. So there was, they also attempted to make arguments that his signature wasn't real or didn't look like all his other signatures. So that's a really interesting dynamic. What do we do when we have a blind person, a blind testator or blind executor or grantor?
So every law firm and every office probably has their own procedures. But one of the things that we do is we make sure that there are third parties in the room and the attorney who drafted the will reads the entire will or the entire trust word for word, no skipping over, no summarizing, word for word to the grantor, the testator, to make sure that they know what's there. I've also had it transcribed into Braille for somebody who was blind. I'm sorry, for somebody who was deaf and couldn't hear. So, it all depends on the office procedures.
Wow. Yeah. That's a lot of reading. I've got like 40, 60-page trusts. Oh my God. So that's the story of Ray Charles. You've got it's a lot of planning involved. And so if you have a situation where somebody's blind or has a disability, it's really important to get a good attorney who knows how to handle those situations and can do the proper planning. So those are our 2 celebrities estates that we're talking about today from the Trial and Errors books. And I don't know if you wanted to add anything, Christina.
No, just it's really important that you make sure that you have, your estate planning documents in place And once they're in place, as we saw with Al back in Jimi Hendrix story, always make sure that they're updated. Maybe you are the ones at 27 and you came into some money, so you do your estate plan and you don't have kids at that point, but 5 years down the line, now you do. Or, you do your estate planning and you're in your 40s and you have kids already, but now one of your kids has special needs. So it's always important to make sure that you look at them. I say every few years to make sure that they're all in accordance with your wishes, that nothing's changed, that there's been no new life events. So that's important. And it's going back to the co-executors to make sure that the people who you appointed in your documents are still alive and you're still in touch with them.
Great. Well, we hope you guys appreciated and enjoyed the stories, and we'll have some more for you guys soon. And thanks for listening.
Thank you.
And thanks, Christina.